Well, good morning, everybody. This is Bill Krizner, and I want to begin by just saying thank you to the Chamber and for the partnership that we've enjoyed for so many years. This is a really difficult webinar to provide because we all are facing very challenging times. In fact, unprecedented times in our country. And I know that they're unprecedented for you as employers as well, as you make some really difficult decisions. And so our hope over the course of the next hour is to provide you with some guidance and insight in a number of areas that I think will prove beneficial. Just to give you a little bit of background, our firm has received almost 2,700 questions in the last week and a half from our clients. And I want to start by also thanking my team for all their incredible work. And I'm delighted that two of my very best are with me today, and Joyce Chastain and Jason Taylor. The way we decided that we were going to go ahead and do this webinar is we're going to divide it into three parts. I'll begin by talking to you a little bit about what has quickly become perhaps the most asked about topic, that being layoffs, furloughs, and reorganizations. Joyce will then discuss dealing with symptomatic employees, telework, and of course the two new leave laws that have created so much confusion. And finally, Jason will address some of the most frequently asked questions that we're dealing with on our firm's hotline. So we're going to dive into the reorganization piece to begin with. And I think, again, you all are following the news like we are, but the projections right now for the economy are very bad. Senior federal officials suggested yesterday that unemployment could hit 30% by the second quarter of the year. And just to kind of put that into perspective, remember at the very peak of the 2009 recession, we hit 10%. And this is really dire, but if you remember the Great Depression from all those years ago, it peaked at 25%. And this statement seems a little dire and a little dramatic, and candidly probably a little irresponsible. But even the conservative estimates, though, that we're looking at indicate that we'll probably experience a historical record over the next month in layoffs. Bank of America forecasted 3 million jobs lost when tomorrow's numbers are released. So again, that gives us a little perspective of where we are and some of the things that we're going to have to be considering when it comes to reorganizations. And even worse news is that the blood is in the water. Joyce and Jason will probably speak to this in just a moment as well. But we received, or intercepted, if you will, yesterday, a blast that went out from the most notorious plaintiff's employment firm in North Florida, one that many of you know very well from past lawsuits. And they're already advertising and promoting potential mistakes that you as employers are making when it comes to things like layoffs and complying with these new leave laws. So now is obviously the time to be as proactive as we possibly can and to really think through every decision with litigation in mind. And I can't overemphasize how important it is right now to be working with legal counsel and just sort of thinking through what might happen based upon what you're deciding. So with the splash of really cold reality, I guess we should go ahead and talk a little bit about the best approach to layoffs and furloughs. And I think most people on the line understand the term protected classes, and it's through that lens that we have to consider the dangers that are inherent in the reorganization. So for those of you who are a little less familiar with the concept, remember that before 1964, Florida, and frankly most of the country, was completely at will, meaning that you could fire people for any reason at all with almost no exceptions. But then the Civil Rights Act was passed, and followed by a series of other laws since then, all providing the ability to file a lawsuit against an employer that they believed acted because of one of these protected classes, a characteristic that has been historically discriminated against and was then built into one of these laws. Again, they're ones that you know: race and religion, age and pregnancy, national origin, disability, veteran status, sexual orientation, and a host of others. And the laws have all been designed such that it becomes very easy for an employee to bring an action. And then what happens, of course, is the ball bounces into your court and you have to spend extensive monies to prove that the motivation behind the termination, or in this case, as we're talking about the layoff, was for some reason other than the protected class itself. So with that kind of, again, as the backdrop, when we go about doing layoffs or furloughs or reorganizations, our firm developed a philosophy, if you will, dating back to the last recession more than a decade ago. And what you note is that the EEOC, the Florida Commission on Human Relations, and judges and juries I want to be certain that you're going about these decisions in a fair or equitable way. So what we recommend is that you take a look at your entire workforce, and it's very clear that you did that from the beginning. And the way that I always describe and train on this topic is with a word picture. If you remember when you were kids, or if you have kids, the sand tools, the sand sifts, if you will, we used to play with at the beach. And what happens is you take a hand shovel full of sand and you pour it through the top. And then the combination of shells and pebbles and sand would start to pour through the toy. Well, there were different size screens that were just under that top, that sift. And the first one would capture the largest pieces, the second would catch the medium, and the third would catch the small ones. But what ultimately pours out the bottom, when it worked, of course, was the pure sand. And this is the same philosophy that I think that you're going to want to apply when it comes to reorganization. We're going to want to pour the entire workforce into the top. And then what we do is we allow identified screens, objective screens, to capture some of the employees or some of the positions that will then ultimately be displaced. And then at the end, of course, is the remaining workforce, the workforce you intend to continue to employ. And we do this through a particular format. We document this in something called a reorganization memorandum. So all of you out there, HR professionals, business owners, and other leaders, this is a really important piece. We start to create a reorganization memorandum that shows how we go about creating the screens. And so you see on the screen that basically we indicate that there are 3 pieces to this memorandum. The first part of the memorandum should give some explanation as to why you're going about it. Very clearly right now we're in economic turmoil. What does that mean for your business? What numbers are down? What projections are down? And when we start to describe what that might look like, we create a legitimate basis for the decision to begin a reorganization. And this is, again, a very important part. The other piece that we want to make sure is in that first section of the memorandum are the other cost savings that you're going about. So maybe you're saving on utilities, maybe you decide to cut certain vendors. Whatever that is, we want to show that we're making a holistic approach to cost savings. And this is part legal, right? But it's also part human. Because ultimately, when we have to defend these cases and people are arguing, well, why did you choose me? Why did you have to pick my job? We want to be able to show it's because we had no other choice. And the memorandum should take that tone as it's being created and documented. The second part of the memorandum, which is the very important part, is the identification of the screens themselves. And there's a variety of screens that you can use. Our favorite, of course, is last hired, first fired. In other words, tenure. But very rarely do organizations want to take that tact because oftentimes you've just hired somebody who's a very good employee, a very productive employee, and so you don't want to be displacing them or placing them on furlough. So that's usually not a viable option for our business owners. Another screen is something called non-essential, right? It's a position that doesn't really drive revenue. It's not a profit center. This is, gee, my CEO has an executive assistant, and when push comes to shove, my CEO can answer the telephones herself. And therefore, as I begin to decide which positions will be impacted, it seems to make sense that we're going to go ahead and pick the executive assistant rather than our top salesperson. And courts give you complete deference when it comes to that. Utility is another screen that you hear a lot about. And that is, again, for many of you small businesses out there, you have folks that can do 3, 4, 5 different jobs. And you also have people that are far more specialized. And so, when I have to choose between those 2 types of employees, as I downsize, as I reorganize, as I quote right size, I need to make sure that I'm holding on to the most valuable individuals. That has to be explained and set forth in this reorganization memorandum. And of course, the one that everybody really wants to use is performance. And there lies the problem, though, because when we go about choosing people on the basis of performance, oftentimes we don't have historic documentation that explains how one employee has performed better than another. Hopefully and prayerfully, you're able to go back and look at the most recent annual evaluations and performance evaluations. And those evaluations should draw some distinction in the level of performance from one employee to the next. In some situations, you probably also have corrective actions or disciplinary actions that are in the file. That's another piece that we can cite to in terms of making these decisions. So in the second part of the reorganization memorandum, we're saying we've picked these 2 or these 3 screens and we've applied them to the entirety of our workforce. And when we do that, the result is ... And the result is the third section, right? This is where we actually identify the positions and or the employees that will be placed on furlough or that will be permanently laid off. And as we identify them, then there's a short sentence or phrase that follows that ties them or connects them to one of those screens that we've identified earlier in the memorandum. And the beauty of this, of course, is when we're doing a deep furlough or a deep layoff, all kinds of employees are being impacted, right? And what I mean by that is there are different races, there are different ages, there are different genders. And it becomes very difficult for one of those employees later to bring a successful discrimination lawsuit because we're able to cite to a larger population that was impacted at the same time. So the fourth piece, though, by the way, is the timing. So there really are 3 primary sections of this reorganization memorandum. But in some of your cases, you're out there right now trying to decide, when will I do this? When will I pull the trigger? And what we've been urging all of our clients to do is to go ahead and actually engage in this exercise, this reorganization exercise now, even if you're not prepared to do a layoff or a furlough tomorrow. And the reason being is, 1, it's a good exercise for your future, the future of your business. But 2 is, the sooner you can identify those individuals, the better. Because otherwise, what often happens is you get down the road and let's say a month from now, things haven't turned around at all. And now you're preparing to execute the reorganization. Well, one of those employees that you plan to impact has come forward and told you that she's pregnant. Another one comes forward and discloses a particular disability that they have. It now becomes very hard to include those individuals in the reorganization, whereby if I would have gone ahead and worked through this exercise and identified them earlier, it would still make sense and it would still be very defensible to follow through with that potential plan. So the reorganization memorandum is absolutely critical when it comes to right-sizing the organizations today. A couple other little points that I want to note before I turn it over is real challenge is to decide how deep do I go, right? I want to go deep enough, but I don't want to go so deep that it creates permanent damage to my organization. And there is no magic pill that we can send to you on that front. I will tell you, though, living through this the last time in the Great Recession, what we found to be particularly harmful to workplaces is a concept called splicing. And it's the idea that you do layoff after layoff after layoff. And what it does clearly is it devastates morale. But on top of that, what happens is that some of your better employees, the ones that you would never dare impact, right, start to get very nervous and they dust off their resumes and applications, and then they voluntarily leave you high and dry. And so we want to make sure we're thinking through how deep can we really go. And that's why a lot of our clients right now have not decided on final layoff, forever layoffs. Many of them now are more in a furlough stage where they're sending people home ultimately unpaid in hopes that they can retain many of those employees. I'm almost out of my time for the presentation, but the other thing that I do want to emphasize to everybody out there is that you do want to make sure you're working through this again with counsel. One of the things that we do with our clients before they engage in reorganization is we ask them to show us the entirety of their workforce, usually on an Excel sheet. We ask them to identify race, religion, gender, age, disability, all those protected classes, and then to actually highlight the individuals that they plan to impact. And what that allows our team to do is to do a risk assessment and to identify any potential areas of concern. And sometimes we're able to offer some advice to mitigate against the risk inherent in the proposed reorganization. So this is what we're up to. We're spending lots and lots of time working with our local clients on this front to help them prepare for the reality that they are going to have to reconsider their workforce and to sort of right-size it for this next period. So with that in mind, I will now transition over and ask Joyce Chastain to speak to you on a variety of topics, including the new leave laws.
Thank you, Bill, and good afternoon, everyone. So what do you do if you notice an employee is exhibiting symptoms of COVID-19. In short, you send them home. By now, you've probably all seen the charts with the assorted symptoms of the virus, but the primary ones you might notice in the workplace would be cough, shortness of breath, or you may hear complaints of fever. In the CDC's guidance for business and employers, we're told that an employee may return to the workplace once they're fever-free for 24 hours. So send your employee that's exhibiting symptoms home. Don't send them to the doctor. Medical certifications validating the need for an absence should not be requested at this time. Rather, federal authorities are requesting that employers rely on the integrity of their employees and allow self-reporting for the need of an absence. Under normal circumstances, you may not take an employee's temperature since that constitutes a medical exam under the ADA, and employers may not conduct medical exams. However, we are not in a normal environment now, and the revised EEOC guidance released late last week tells us that employers may measure an employee's body temperature before allowing them into the workplace. We're recommending that if you do this, you use the no-touch method to do temperature screening, and also create a document to memorialize that the employee was exhibiting symptoms of COVID-19 and was sent home. Keep in mind that that document needs to be placed in the employee's medical file along with any other documents related to their absence resulting from the coronavirus. Medical clearances to return to work also should not be required at this time. Rather, have the employees attest that they're fever-free and have been so for 24 hours without the assistance of fever-reducing medications. Now, what do you do if an employee informs you of a diagnosis or you have reason to suspect that they may have the coronavirus and you send them home? You do have an obligation to inform their fellow employees of the potential workplace exposure. Communicate to them that there has been a potential exposure and inform only those who have a need to know. Don't create widespread panic. There's no need for a company-wide e-blast, for example, if that employee works in a facility that only has a few people. You should also send home to self-isolate all employees who worked closely with the employee who has been diagnosed or who exhibited symptoms. Those potentially exposed employees should remain home for that 14-day self-isolation period of time to ensure that the infection does not spread further throughout your workplace. You may also want to communicate with anyone else that your employee may have come in close contact with. That might be vendors or subcontractors or service providers, maybe customers, clients, just to let them know that there has been a potential COVID-19 exposure. I can't say this strongly enough. Do not reveal the name of your employee who has been diagnosed or who has informed you of a diagnosis or a potential diagnosis. To do so could certainly put you at risk of ADA claims. Many of our our clients have already initiated telework procedures with their employees. For those positions in which remote work is a practical consideration, we recommend it, but we recommend it with some suggestions. We recommend that you have very strong job descriptions that clearly articulate the expectations for successful performance, including to the extent that's possible, anything related to remote working. Establish pretty strong ground rules on how interactions will take place. If you expect regular check-ins, be sure you state that. Also include your expectations for how quickly an employee will respond to an email or return telephone calls. these are things that are normally not spelled out in a work environment where people are getting up and going to an office to work, because if you need them, you just get up and go into their office. Establish clear lines of authority and set performance goals, and then hold employees accountable to those goals. Make sure that those folks that you're sending home to work have the right tools. That might include a quiet place to work, a strong internet connection, a laptop with video capability if you plan to have conferencing meetings. Maybe a strong cell signal might be required, office supplies, whatever they need to be successful, make sure that they have those tools. It's also important that your supervisors know how to manage remote employees. They will no longer be managing by vision, and instead of managing employees based on effort, we're now going to be managing based on results. We recommend that supervisors speak regularly with their remote workforce. Daily is the best approach. Maybe that communication could be by telephone, email, or even text message. It is considerate to provide plenty of notice for an expectation for a collaboration or a conference call. Remember, your remote workers are trying to keep their work current, but they may also be dealing with other issues during the day in addition to their work for you. Many of them may have school-age children. They may be helping their children do their distance learning. Be respectful and schedule calls if possible. And also recognize that your employees, while they are teleworking, may be working on a different work schedule than they might be working if they were coming into the office. Give them frequent feedback, quality and quantity of work. Make sure that they know that they're meeting your expectations or they're not. Develop a policy that includes all of your specific expectations, and ask your employees to acknowledge a remote worker agreement. Now, as Bill said, we're going to talk about the new laws that, or the new leave that has been generated by the Family First Corona Response Act. For those employees who cannot work from home, we now have some job protection for them through this act. This new legislation, which goes into effect on April 2nd, applies to employers with fewer than 500 employees. Emergency responders and medical providers are exempt, although we don't have a very clear definition on what constitutes a medical provider just yet, but we do expect that it will be fully defined very soon. And one of the other things you may notice as I go through this is I'm going to be saying a lot of times there's just stuff that's unclear. There are things we don't know yet. That's one of them. It's also important to know that the FMLA requirements included in this legislation apply to employers with less than 50 employees. That's a distinction from the pre-existing requirements of FMLA, which apply only to those employers with 50 or more employees. There is an opportunity for small employers with less than 50 employees to apply for an exemption from this requirement, but only if they can show that the viability of the organization would be threatened if this leave was granted. One of the questions that was submitted in advance of the webinar was, how do we apply for the exemption? Well, more detailed information should be coming forth from the Secretary of the Department of Labor, but we do have some ahead of the game guidance, and that is, in advance of knowing exactly how to apply for the exemption, you need to be creating a list of the essential functions of your organization. You will be required to show how the organization will be financially impacted or how the mission of the organization would be at risk if the leave was allowed. Now, keep in mind that the financial impact cannot be because you're granting this leave, because this leave is going to be reimbursed at 100%. The financial impact has to be related to being short-staffed. Also, it's important that you kind of do the math on this. Determine what percentage of your workforce have children under 18 that could potentially be eligible for the FMLA expansion leave, there's no reason to apply for the exemption if the requirement's going to have minimal impact on your organization anyway. The Department of Labor also announced that there's going to be a 30-day non-enforcement period as long as you can show that you're making good faith efforts towards compliance. We're going to talk about this provision in 3 dimensions. Your employees are eligible for 2 weeks, that's up to 80 hours, of paid sick time at their regular rate of pay if they cannot come to work because they're quarantined by a government order or by advice of a healthcare provider, and or they are personally experiencing COVID-19 symptoms and are seeking a diagnosis. It's important to note that a self-imposed quarantine by your employee without medical advice does not qualify your employee for this leave under this Act. You're required to pay that employee who otherwise qualifies their full wages up to a maximum of $511 per day. If the affected employee is full-time, they're entitled to that 80-hour maximum. Part-time employees are entitled to the typical number of hours that they would work in a 2-week period. If they had an unknown schedule or maybe they worked as needed, then there's a historical look back calculation that you will do. But all employees are eligible for this. There is no length of service requirement as long as they work for an employer that has less than 500 employees. The emergency paid sick leave also covers employees who are unable to work because they're caring for an individual who is subject to a quarantine or isolation if they have been directed by the government or a medical provider, or if they're caring for their child whose school has or daycare has been closed due to COVID-19 precautions. And the other way that a person would be eligible for this is if they are experiencing substantially similar conditions as specified by the Secretary of Health and Human Services. Now, the precise meaning of that last reason is unknown at the current time, but is supposed to be clarified by the Secretary of Health and Human Services later this week. So stay tuned for that as well. Also, go back for a minute. Did you notice that I said the employee is caring for a quarantined individual? Currently, it is not limited to a family member like the other provisions of FMLA are, although there is a minor stray reference to family members elsewhere in the Act, so we may get some additional clarification on that as well. Under this provision, you're required to pay these employees 2/3 of their full wages, not to exceed $200 a day for that 2-week period of time. If they're full-time, that's 80 hours. If they're part-time, you use the same calculation as you did before, either their schedule or doing a historical look back. And once again, there's no length of service requirement for this. Anyone who's worked for you for a day would be eligible if you have fewer than 500 employees. The third dimension is the Family and Medical Leave Act expansion. Under this provision, employees who are unable to work because they're caring for their child whose school has been closed or their daycare or childcare is unavailable because of COVID-19, they're eligible for additional paid and job protected leave. Employees in that eligibility status are required to be paid 2/3 of their full wages, up to $200 a day, for an additional 10 weeks. Again, the same calculation for part-time employees. Now that gets you to a total of 12 weeks for employees who have not, who are impacted by this, primarily in this case because their children are out of school and they have to care for them. The first 2 weeks of that leave was covered under the emergency paid sick leave, and the balance, the remaining 10, were covered under the FMLA expansion. An employee is eligible for this paid leave if they have been with you for 30 days. While these leaves are required and you are required to continue their pay, you can receive 100% reimbursement of paid leave that is paid to your employees in accordance with the Act. This is going to be handled through a payroll tax credit, and it's going to be administered by the IRS. If it turns out that the amount that you paid to your employees to cover this leave is greater than your employer portion of the payroll tax liability, then a refund will be coming from the IRS. There are also some additional tax credits for maintaining the health insurance coverage for employees that are eligible for this leave. And again, more details about how to apply for that credit is going to be given to us through the IRS, hopefully very soon. Just some final thoughts on this topic. These provisions are temporary. This legislation sunsets on December 31st, 2020. Paid sick leave cannot be, this paid sick leave that we're talking about here, this 80 hours for full-time employees, cannot be carried forward into another year. Their eligibility for these paid leaves ceases immediately upon termination of the need for the paid leave. So if schools were to resume, then this eligibility would go away because they would no longer be out of work because they were having to care for a child whose school had closed. It's also important to note that all eligible employees may use paid sick time beginning on April 2nd. And on or before April 2nd, the Secretary of Labor is required to issue guidance to assist employees in how to go about calculating the leave benefits. Most of you, many of you provide some form of leave to your employees now, sick leave, paid time off, or vacation time. You cannot require your employees to use other leave prior to using this leave. This leave is required in addition to anything else that you may otherwise provide. There is a posting requirement. You are responsible for informing your employees of this law and their rights under the law. The exact language we don't have yet, but it's due tomorrow. The Secretary of Labor is supposed to create the language for that poster and provide it by March 25th. So before you communicate anything to your employees, because there is so much unknown at this point, wait until we get the specific guidance from the Department of Labor to share any news with your employees. There's just too much that's still subject to interpretation, and we want to use their language, the Department of Labor language, when we're informing our employees. Now, how do we receive back into the workplace formerly ill employees? If you're in a non-healthcare setting where individuals in the workplace are not at a greater risk of contracting COVID-19, employees may return, as I said earlier, once they are 24 hours fever-free. And I underscore allow it, but don't require it. That's because some of your employees, even though they may have been fever-free for 24 hours, may still be too weak to drive or to return to work. So while you may allow them to return to work, we do not recommend that you require them to do so at that point. Again, don't seek a medical clearance for their ability to return to work. The directive from the White House Task Force says our healthcare workers are far too busy to be providing notes for employees to go back to work. Keep in mind that all of your employees' health information is protected. Don't speak openly about an employee's diagnosis or their return to work. And one last cautionary piece of advice, don't impose additional restrictions on that employee, such as moving them to an isolated area to work, or making them wash their hands more frequently than others, or not allowing them to participate in meetings. I know we've covered a lot of information and you probably have a lot of questions. I'm going to toss it over to Jason Taylor now to respond to some of the ones that we're hearing most frequently.
Good afternoon, and thank you again for being here and for the opportunity to work with you on these issues. The first question we have up is regarding the FMLA expansion. Does the time away have to be continuous? We're wondering if the employee has the right to take 3 days off and 2 days later. The answer to this question is right now, because this is a section of the FMLA that has been added, and there is no language that says that this has to be consecutive. This is leave that can be taken on an intermittent basis. This is just the FMLA expansion, not the paid sick leave. So be sure that you know the difference between the two. But what we did see is in the initial bill from the House, there was a requirement that this could not be intermittent. That was removed from the bill that the Senate passed, and that's at this point, while the language doesn't specifically speak to it, because of that removal, we're kind of using legislative history to come up with this interpretation that this would be intermittent. Some of the concerns that come along with that are, well, this is going to extend that time frame out. And the short answer is, yeah, it may very well. However, the leave only applies for the period of time that the school or the daycare or the need for care is there. So if, you know, hopefully this changes and we have kids going back to school, daycare's opening, it won't extend it out too far to where we're looking at the total time. Okay, let's go to the next question. What if my employees need to be out before the April 2nd, 2020 Act effective date? How should we handle that situation? What we've gotten from the DOL and the Department of the Treasury is that this law, employers can start taking advantage of the law and the tax credits as early as 3/20. That's when they issued their press release and said employers can start doing this. One of the key things associated with that, though, is to make sure that if you are giving leave for these reasons, that you are documenting that and it is something that you are communicating to the employee. What we don't want to have happen at any point is there be a situation where the employee, you know, this is not documented, and then later on the employee gets to April 2nd and says, okay, now I'm going to take my emergency paid sick leave back. Make sure to document it, make sure to provide that information to the employee, and that way, if you're doing that, you should also be able to get the tax credit. Be careful, though, that if you are taking the tax credit at this point, you also have to provide the leave. Don't think you can take the tax credit and not provide the leave. Next one, does the new form of FMLA leave add 12 more weeks of leave if an employee has already used FMLA for another purpose this year? The language in the new law is not directly specific to this, but here's what we're thinking. This is a new category that was developed under the provision that an employee will have 12 weeks. So what they had before was the law starts with, or Family Medical Leave Act starts, an employee shall have 12 weeks of leave for these reasons. And this added a 6th category to the already existing 5. So our position at this point, without further information from anybody else, is that this is leave that there is a maximum of 12 weeks regardless of what the reason is. So it's a 12 weeks for any of the reasons, but you don't get 12 new weeks. Question number 4, does the requirement vary based upon the size of my company? Yes, but it's 500 employees or less in the private sector, which is going to cover a whole lot of employers. So if you have less than 500 employers, there's not really anything else that you need to worry about if you're a private employer, other than the fact that we'll be looking for the information related to how to seek an exemption. For public employers, please understand that just like with the normal FMLA, this applies to you regardless of the number of people. Question number 5, can an employee claim workers' compensation for getting coronavirus? I wish I could offer a direct and simple answer to this. We did have a post that we can probably provide, but there is a process under the Workers' Compensation Act that relates to occupational disease. And generally what is required is that the employee has to show that they received the disease because of the nature of their work, that they contracted the disease at work, and that the nature of the work was the major contributing cause. All of that is kind of people that do workers' comp and practice that a lot know kind of a lot of these terms, but what it basically means is that you have to have kind of a special risk at your work that separates that from other work, and that separates from you being able to get this illness from somewhere else. So for many people, this is probably going to be a very difficult thing for an employee to prove that they got the coronavirus at work versus any other contact that they may have come into people with. However, be aware of that. If it's claimed, make sure to document the information that you have. Always make sure that you're getting the information that's available. It is the burden of the employee to prove this, and they have to prove it by medical evidence. Question number 6, what do I do if my employees are refusing to come to work right now? I know they're frightened, but we have a job to do. With the new laws, if they're qualified, they get the leave. So that's an easy part of it. If they're not qualified, this is really a situation where we're talking about appropriate communication, making sure that you're doing what you can to demonstrate, to 1, that you are creating a safe workplace, 2, that you're communicating that to the employees, and then 3, being patient. Because, and at some point it may be that discipline would be appropriate, or that you need to take action at some point to fill some of these places where people are not coming to work. But right now, what we anticipate is, because of the situation, this is going to be something where courts are probably going to be more sympathetic to employees. So as you are taking actions, make sure that you are doing everything possible to demonstrate the workplace is safe, and communicate to the employees, and documenting that you're doing that. Oftentimes when I'm talking with employers about the issue of employees not coming to work for one reason or the other, this is something where I like to use a 3 strikes rule, where you start with information, ask them to come back. The next step is, I asked you to come back, I'm asking again, and then kind of the 3rd strike is when you may need to take disciplinary action. But that's something that is going to be a case-by-case basis, and that's what we're here to help with. Question number 7, is the leave provided in addition to accumulated PTO, or can accumulated PTO be applied for this required leave? For the Emergency Paid Sick Leave Act, this is new leave. You cannot use accumulated PTO. This is something in addition to whatever you have already provided. For the Family Medical Leave Act expansion, that 2/3 that is provided, this is also new leave that is provided based upon the information that we have from the statute. This is an area that is, hopefully we're going to see a little bit of guidance on, but the situation right now is that there is a provision that says this leave is unpaid for the first 2 weeks, and then this leave is paid for the next 2 weeks. And the statute, or the law, says that employees can use their PTO for those first 2 weeks, doesn't make the same provision for the 10 weeks after that. So right now, what we're understanding this law to be is to add that leave to whatever is existing. Now, we also believe that, similar to other types of FMLA leave, that an employee may be able to supplement that other 1/3 that they're missing with their PTO. In this particular situation right now, we don't feel comfortable saying that you should require them to until we get a little more guidance on that, but they should be at least allowed to do that. Question 8, are there exceptions for nonprofits? And I wish I had a longer answer, but the short answer is no. This applies to every single employer. Now, sometimes the questions that we're getting are that nonprofits say, well, we don't pay certain taxes. However, the majority of nonprofits pay payroll taxes, and that's where the credit is. So, question 9, does this leave apply if I send an employee home because of flu-like symptoms? This is always going to be a factual issue, but if the symptoms are not the coronavirus, right now, there is a reasonable interpretation that if we're not talking about coronavirus symptoms, then this is not leave that's available under either the Emergency Paid Sick Leave Act, and that's the only one that would apply. It's not childcare. So in this situation, unless there are symptoms related to the coronavirus, which is I believe it's the 3rd category of that EPLSA, or the last one where we're waiting on particular definition from the Secretary of Health and Human Services, if those aren't the things that you're sending the employee home for, they can use PTO, but it probably is not going to be leave that is for which the sick leave provisions are applicable. Question number 10, what proof can I require for 12 weeks of FMLA for a child that is out of school, or to care for a child that is out of school? And do both parents get the leave if it's a 2-parent household? We are working with our clients to try and figure out what information is appropriate. And this is, again, going to be a factual situation, but you are allowed at this point to ask an employee to affirm that they have a need for the child care and that they are taking this leave because of that purpose. I think in this particular situation, the law is designed to give a fair amount of credit to the employee and rely on the employee to be honest about this. That doesn't mean if later on there's a basis for you to indicate that there's been some sort of untruth, that discipline may not be applied. But on the front end of this, what we're looking at is that this is something where if the employee is able to affirm this and you don't have any contrary information, it would be a bad decision to deny that leave. Now, if you learn of something else later on, if you learn of a basis for there to be some indication that something's untrue, that may change. Second part is, do both parents get the leave if it's a two-parent household? This is going to be something that will also be based upon reasonable circumstances of the family. It could be that you have parents that both work and are both trying to work some, but not all the time, and care for their children. And so in that case, it's likely reasonable that a court would allow that to occur. And yet to be tested, but what we kind of are waiting to find out is if there is already a parent at home who normally would care for the children, can the working parent also take this leave? And that's going to also depend upon the facts of the familial situation. There may be a basis to legitimately deny that leave, but be very careful about that and make sure that you're getting all the information if you're considering that.
Dana, those are the questions that came in advance of the webinar. I know as I was watching, it looks like we had about 14 or 15 questions come in during the webinar. Can you field those for us?
Absolutely. So we have had people submit in the Q&A portion, but also in the chat. So we probably have 25 or so, and you guys will just, if you've already answered, I tried to look, but anyways, I'll just start from the top. So one question, what kind of policies should we put in place for remote employees? And I know you guys talked a little bit about, but I just want to make sure that I've asked all the questions here.
Well, what we want to make sure we specify are the specific essential functions of the job that can be performed remotely, and an acknowledgement from the employee regarding the expectations of leadership. And that could include how often we expect them to interact with others, how often we expect deliverables to be provided, anything related like that. If it's an expectation of the employee, get it in writing and get the employee to sign it.
Okay. As of Thursday, March 26th, the company I work for is requiring all employees to work remotely until further notice. How or what is the best way to deal with contingent workers? The company I work for currently has 30 contingent workers, and all but 3 are able to work remote during this time. The other 3 work in business units that provide critical manual work to the business and cannot do work remotely.
Well, I'm struggling because I'm not sure how you're using the term contingent, but it sounds like it may be their own call, or maybe they sit on the bench until they're called into active duty. If that's the case and there's no work for them, then they would most likely be furloughed. If they are essential, and it sounded like from the rest of the question that some were and some weren't, if there are some that are essential and maybe contingent means that they are independent, maybe a 1099 or a subcontract, the same expectations would apply. It'll just be slightly different because they'll be earning their job based, or their money based on deliverables, as opposed to earning pay. And I hope that helps. If not, maybe restate it a different way.
Okay.
Just to follow up too, this is loosely related to that question, but I want to make sure everyone is clear that when we send people home and we put them on furlough, the non-exempt individuals are not owed any type of specific monies. But with exempt people, those that typically are not eligible for overtime, and there are some of those folks that are now being sent home as well. If they do any work whatsoever during that week, the entirety of the week must be paid. And where we've seen a lot of snafus in the past is when we send people home and that exempt individual is checking emails, they take a call, anything like that. So if they still are connected through their laptops, their telephones, et cetera, there is a very strong likelihood that they continue to work. So employers need to be mindful of that and the potential Fair Labor Standards Act consequence.
Okay. Does the date that the school year would have ended have any impact on employers' obligation to continue to grant extended paid leave for care of non-infected children under 18?
The issue with this is that if there are situations where an employee would regularly have a child in daycare and that care is no longer there, then the likelihood is it will require it to extend beyond for those employees. This is just personal opinion, I'm not crazy about the 18-year-old kind of age limit, but right now, without further guidance, if there is a child that is out of school and normally would attend some sort of care and that care is not available, there's a reasonable likelihood that it would be required.
I think, so this one, I think maybe you guys quoted not sending a mass email to everyone if someone in the office has exhibited symptoms. This particular question relates, they have a total of 7 employees in the office. If one is sent home, everyone will know. Any guidance, and you might have touched on that in the webinar as you talked through, but.
So thanks, Dana. And you're right. In a smaller environment, it's going to be virtually impossible to protect the identity of the employee who's been sent home because they might be the only one that's not there. And then you have the obligation to inform others that there's been a potential exposure. But having employees fill in the blanks for themselves is different than the employer or a representative of the employer sharing the identity of the employee. So our obligation as an employer or a representative of the employer is to maintain that person's confidentiality. If employees fill in the blank, that's on them.
Okay. How do you handle salary reductions rather than using a layoff? Can you give one department a reduction and not all departments, or different percentages across the organization?
The short answer is yes, although it's really important to make sure, again, that we do a memorandum to file that would explain the objective basis for what ultimately would be a disparity in the way that you're approaching your workforce. Where you could run into problems is if one department were predominantly, male, and the other department were predominantly female. You could see where a disparity claim, a group action, may ultimately result. So you would have to explain in that memorandum whatever the legitimate business basis is for that distinction in the way that you're treating those two different groups.
To confirm, is the FFCRA only applicable to roles that are not able to work in a remote capacity?
The FFCRA represents both the emergency paid sick leave and also the family medical leave expansion. So the emergency paid sick leave will apply for those 2 weeks that exist for any of those 6 categories that are applicable. Now the family medical leave expansion applies to those employees whom are unable to work or telework due to the need to care for a child.
If we have short and long-term disability, will that satisfy the Families First Act?
No. Remember that short and long-term disability are private benefits. They're wonderful things to offer to employees, but they in no way replace or supplement the requirements under this law.
I think you guys might have touched on this in the questions, but if we reduce employee hours across the board or lay off employees before April 2nd, how does that affect the application of the new FMLA law?
Right now, because of the way that the law is written, a reduction in time or a reduction in force are not reasons under the Sick Leave Act or the FMLA expansion that qualify for any benefits being paid. It is incredibly important for employers as they're making those decisions to document that this is the reason that we have made those decisions. And just like Bill explained in the reduction memorandum, you've got the business need and all the reasons that go along with it. What is also very important is even if the act is not in effect, if you are taking actions that are singling out those people that would be subject to the act, you may very well be creating situations where you're having a disparate impact based on marital status, which is a protected class in Florida, potentially age, and then also potentially gender as well. So those are considerations to take into effect as you're making those decisions. But at this point, the law not being effective until that time, if employers are having to make those decisions, it does not appear that there would be benefits under the law if they're made before the effective date.
Okay. Can you explain more on the 30-day period related to exemption?
I think this may be applying to the enforcement part of it, and that is not you don't have to do it for 30 days. That is, we're giving you a grace period to make sure that you're doing what you should. So it needs to be during this time period that is that grace period that you are getting everything right as best you can, seeking advice and making those efforts. Now, the other possibility with this question is that the employee has to be with the company for 30 days. That means that before someone can get the benefits under the Family Medical Leave Act expansion, they have to be employed with the employer for 30 days.
If you have less than 50 employees, what is the process to apply for exemption?
It's currently unknown. We hope to know more either tomorrow or before the act goes into effect on April 2nd.
And we expect that we're going to be very busy working with our clients to help them create those hardship applications and documentation.
How does all of this work with straight hourly employees?
It applies just as we've stated.
Okay.
There are a couple of things, like when we're talking about hourly employees for the benefits that they are paid, there is an equation for using the normal number of hours worked in the 2-week period, or you go back 6 months. The third option is that you are looking at what would be expected based upon what you anticipated the person's schedule will be if you don't have that 6 months.
Okay. This is an easy one. I can answer this one. Will you send out the slides? Yes. Okay. What do you do if an employee is afraid to come into an office because they think an at-risk employee who was requested to do a 14-day self-quarantine will not stay home?
Well, this is going to be a very difficult call. The individual wouldn't be protected under any of the laws that we're discussing today. So the employer will have to make a hard decision. If that individual, for example, is over 70, if the individual has other reasons to be highly susceptible, the compassionate thing would be to try to work through some type of remote situation. If that's not possible, could the employer require that employer, those employees to come to work? And the answer is yes.
Can you help us understand the difference between layoffs and furloughs, advantages of each?
Ultimately, from a legal perspective, a furlough implies to an employee that there will be at some point where you're going to be able to return them back to work. And a layoff is the primary difference is there's really no implication in that. From a legal standpoint, there's not a significant difference because you are still allowed to obtain unemployment benefits if your work hours are reduced. It doesn't really change the legal status of the employee except for how the employer may define to provide benefits to people who are furloughed versus laid off. Some employers may choose to say, I'm willing, because these employees I expect to have returned back to work, I have a pretty good feeling about this, I may be able to provide benefits for them, whereas people who are laid off, I'm not. And sometimes that's an economic decision by the employer. But you have to go through the same steps when you're talking about that difference so that you're not creating the issue of impacting a protected class as you're making those decisions.
It's still an adverse action, and there's a psychology to it as well. If somebody's on furlough, they have anticipation or expectation that they'll get to come back. But if they're told they're laid off, I mean, obviously they know there is no future. In terms of their ability to seek representation with some of the local plaintiff's offices, you may be delaying that opportunity at some level, but it's still considered an adverse action.
If we let an employee go this week before they take the leave, does the leave no longer apply?
I think Jason's answer earlier probably addressed that one, Dan.
Okay. If the employee was not scheduled to work and was not required to come to work, we might be answering this again, do they still qualify for the paid sick leave if they become ill with the virus while not on the schedule to work?
That might be one of those situations where you would have to do a look back to determine what their eligibility would be. If they, it sounds like they're not a full-time employee. So to determine, you'd have to do that 6-month look back to see what their eligibility would be, what their benefit would be. And Dana, I also noticed that we are out of time. We don't mind continuing to respond to the questions, but I want to be respectful of the folks' time on the call. So an alternative, if it might be that we create something on the chamber site for a Q&A opportunity, if that would work for you guys. And I know Bill had something he wanted to say before we ended this.
There's just 2 more real quick things. One is I want Jason to go ahead and address a question that we've had a lot of over the last 2 or 3 days because of the action on behalf of some of the other states in the country, and one that may be coming here in Florida.
This deals with the issue of whether or not, if the governor decides, or even a local entity decides to have some sort of isolation order, that is likely to be something that would trigger the first category under the protected, the Emergency Sick Leave Act. So be aware of that if you get that from your county or your city, or the governor ultimately makes that decision, that it would be something we would believe would fall under the isolation order that would require paid sick leave to anyone who was affected by it.
And then really, I just want to close too, Dana, by thanking the chamber once more. I hope that everybody out there found this to be timely and instructive, of course. And I know that 1 hour is not nearly long enough to answer all the many, many questions that are being brought forth. And so we have listed each one of our emails up on the screen. You're welcome to reach out to any one of us or all 3 of us with additional questions that you might have. We're working very hard every day with all of our clients to navigate the challenging areas, and I'd love to be able to do the same with you and your organization. So again, thank you on behalf of the Krizner Group. We greatly appreciate the partnership.
And yes, thank you guys. So I do still have about a dozen or so questions that are here, but I did have some people say that they needed to jump off, and I see some of the participant numbers going down. So we will take these and get them to the Krizner Group that they can answer, and then we'll repost that along with the full recording on the website as well, and hope that you guys find this beneficial. But Bill, Joyce, Jason, thank you so much for your time today and sharing your knowledge with our attendees, and I will be touching base with you guys shortly. And thank you all participants for joining us today.
Thank you, Dana.
Thank you.